effect on the public's liberty or the public's safety, which could be regulated. The expression due process of law and law of the land have the same meaning. The law intended by the Constitution is the common law. It was written with the common law in mind, with the common law terminology, and with the common law as its foundation. That had come down to us from our forefathers as it existed and was understood and administered when that instrument was framed and adopted. That's from State versus Doherty, 60 Maine 504 in 1872. These fellows were a lot closer to the framing of the Constitution than we are today. I did want to say this too, Jim. I really appreciate those emails where you put all that information on. You do a really good job of that. I got the email you sent today about the meeting last week. Yes, you did that. It came from your email address anyway. And I appreciate that. If you haven't gotten those emails, you need to sign up on there. They're a really good synopsis, and they got some extra stuff in there too that I don't talk about. So,
can you repeat the case number?
60 Maine 504. And this particular quote is found on page 509. It's from the 1872 decision.
These meetings are videoed on that site too.
Yeah, he put the YouTube, put it on YouTube, and I looked at some of that. Some of that, I think, like the announcements and preliminary stuff, we probably need to put on there. Just some of the things that you don't know. I know it means you have to get it, stuff like that. But I appreciate that. Because a lot of that stuff gets so lengthy, and people look at the first thing and I would say something pretty good. We're not interested in that. So try to keep some of the meat. You don't even have to put the whole thing, just some real good, some clips or something that are important, maybe 4 or 5 minute clips at a time, where they're in interpreting what due process of law is, it has been held that none of our liberties are to be taken away except in accordance with established principles. Established principles. That's from Eckert versus McGovern. That's a 154 Wisconsin, 157, or an alternative site with one of the regional reporters, 142 Northwest, 595 in 1913. Thus, the mode of arrest by which one can be deprived of his liberty is to be determined by the pre-existing common law principles and modes of procedure. A properly constituted warrant of arrest is a process at common law by which persons could lawfully be deprived of their liberty. The common law on arrest without warrant recognized only certain specific and well-defined cases whereby a citizen could be deprived of his liberty. This cannot be abrogated or changed by the legislature. The legislature cannot change what constitutes due process of law. They cannot pass a law that says, all right, we're going to make this a crime and we're going to arrest you for it without a warrant because we say we can. The legislature can't change the process of law. The common law, and you have to listen to this, the common law drew a distinction between an arrest for misdemeanors, such as that which the defendant arrested the plaintiff upon, and arrests for felonies. When a felony was committed, an arrest could be made without a warrant, but no arrest could be made for a misdemeanor without a warrant unless, listen to this, unless it constituted a breach of peace. The misdemeanor traffic violation is not a breach of the peace. Thus, the defendant needed a warrant to make an arrest for such offense. This is a lawsuit that was filed for an arrest in a traffic case where it did not have authority to arrest on a misdemeanor unless it was a breach of the peace. And that's what this lawsuit is about. In determining the law surrounding arrest, the Supreme Court of South Carolina in the case of State v. Byrd, 72 South Carolina 104, affirmed a prior decision of the court holding that, at common law, as a general rule, an arrest could not be made without warrant for an offense less than felony, except for a breach of the peace. And they go back to a case called State v. Sims, 16 South Carolina 46. It must not be forgotten that there can be no arrest without due process of law. It must not be forgotten that there can be no arrest without due process of law. This is a case that I'm reading from. This is a case that the court makes this statement. It must not be forgotten. Have we forgotten? I think we have. Well, let me correct it. I don't think we've forgotten. I think we just never did. There's a difference. Now the courts have forgotten. I think they've done it on purpose. An arrest without warrant has never been lawful, except in those cases where the public security requires it. And this has only been recognized in felony and breaches of the peace committed in the presence of the officer. Ex parte Roadstool 2 Alabama 68, and there's a whole host of cases here. This is the case. Now, I even read a case where an officer was shot and killed for trying to effect an unlawful arrest. I'm not recommending that. Don't get me wrong there. And when the man proved his case, they had to let him go. I have to look that up. I remember reading the case, I don't remember the case site. But when you start studying this, you start looking up these cases, you run into all kinds of different cases that talk about this, and all sorts of different situations where it has been in play, and that was just one of them. And when you actually consider the thrust of that case, you consider the implications of a man who was faced with an unlawful arrest, who resisted it to the death. That's pretty serious stuff.